Hello, my name is Matcovschi. I'm an intern at the legal department of SPR Ltd. In the following presentation, I will discuss our position in the dispute against MTF AG, which has recently been referred to arbitration. In the recent case where we have entered into a sales contract with MTF AG, for a sale of 4.5 tons of cobalt sulfate 21% for a price of 400,000 euros, and SPR Ltd was not able to deliver the expected product agreed upon. We have informed MTF about our inability to supply cobalt sulfate 21%. Nonetheless, there was no reaction from the MTF to the news. Therefore, we have supplied cobalt sulfate 100% instead in a timely manner. MTF AG is now requesting 45,000 euro for replacement of a good and additional costs allegedly incurred. So, as we see, I will discuss in the following argumentation the relevant provisions, the related case law. Will provide proper legal analysis following with relief sought and conclusion. So, starting from the first argument, MTF has not inspected the goods within a short period as is practicable in the circumstances. Well, the first argument, as you may see present for the situation, is that I have found that MTF AG has not inspected the goods within a short period of time as is practicable in the circumstances. According to Article 48.1, as you may see of the CISG, the buyer must examine the goods within a short period of time as is practicable in the circumstances. Furthermore, Article 39.1 of the CISG states that the buyer cannot rely on lack of conformity if he does not give a notice to the seller within a reasonable time period after he has discovered the non-conformity or ought to have discovered it. So when it comes to analysis, it's important to notice that the goods were delivered in a timely manner to MTF on February 1st, and MTF only examined them 7 days later on February 7th and called SPR immediately. The goods were delivered to the buyer's manufacturing plant in Oberhausen. It would be reasonable to assume that a delivery of dangerous chemicals worth 200,000 euros be examined as soon as possible without leaving it for 7 days in the warehouse. We have found that the nature of such particular chemicals changes if it is not stored in a proper condition. Cobalt sulfate has to be stored in a stable humidity above 70% and room temperature so that it keeps its chemical properties. MTF AG could not have stored the cobalt sulfate in proper conditions had it not known that the goods they have been delivered are indeed cobalt sulfate. So, based on that, we can conclude that MTF has waited for too long to examine the goods than it would be normally expected of them. Therefore, the case would be different if the nature of goods was different. But when it comes to chemicals, the inspection should be done as soon as possible. Therefore, waiting for 7 days to examine the goods is not practicable in these circumstances. Going to the second argument, there's the claimant MTF AG that has not shown any impediment beyond its control to prevent it from doing its obligation of investigation within a reasonable period of time. Well, this is another argument in favor of our company, SPR Ltd, that follows from my previous argument, which is that MTF has reasonable time. Well, this is mostly due to the fact that SPR has delivered the goods according to schedule on 1st February, and MTF has transferred the payment for those goods on February 4th. Well, nonetheless, MTF AG has inspected the goods and sent a notice of non-conformity on 7th of February. Well, under Article 79.1 of the CISG, It has been stated that a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond her control. In addition to this, the judgment of the case 2251 Handelsgericht des Kantons Zurich, sorry for my mispronunciation, of 1998 from Switzerland has ruled that the buyer bears the burden of proof for reasonable examination and the notice of non-conformity, and after having accepted the goods without giving notice of non-conformity, the burden of proof shifts to the buyer. The court ruled in this case that the examination has not been carried on time. Well, as a result, because the payment has taken place before the inspection of the goods and no reason was given to the delay, it can be concluded that the claimant has accepted the goods. MTF AG has not given a reason as to why they have first made the payment and only examined the goods 3 days later, 7 days after the original delivery. Looking at the Swiss case, by accepting the goods and paying for them without sending the non-conformity notice beforehand, the buyer has also accepted the burden of proof, which means that in our case, the MTF has received the goods, made the payment after 4 days, and eventually examined the goods after 3 more days, and subsequently sent the notice. Moreover, MTF AG should have first examined the goods to confirm they comply with the contract, and if they do not comply, they should normally send a notice immediately rather than accept the goods and pay for them beforehand. Well, this says that under Article 79 of the CSG, as I have mentioned before, MTF has not provided a reasonable point as to why they have examined the goods and sent the notice after accepting the burden of proof, subsequently failing the obligation as a buyer. My third argument is that SPR Ltd sent the non-delivery message to MTF on 7 January, which they have the MTF had not reacted to it and instead accepted the delivery of goods on 1st of February 2022. This is on the basis of Article 49, paragraph 2bi of the CSG, which states that in case the seller delivered the goods in a timely manner, the buyer cannot declare the contract avoided unless he does so in respect to a breach other than late delivery within a reasonable time after he knew or ought to have known about the breach. SPR has called MTF a month before delivery to conform with contract. This was communicated to the purchasing director of MTF, but the call was taken by his secretary, who further informed the purchasing director of the telephone call that has taken place via text message. Well, nevertheless, the goods were delivered to a buyer in a timely manner as stipulated in the contract and did indeed not conform with the goods originally outlined in the contract. So Article 49 is applicable to our dispute. It is also reasonable to assume that the purchasing director of MTF would read the text message from his secretary and react to the information relayed to MTF by SPR. So what should be the relief sought? Well, we believe that on behalf of SPR Ltd, it would be advised that the company seeks relief from MTF AG. As we have a good defense against the claims of MTF, we should argue that we should not cover the difference in the replacement of the goods worth 20,000 euros, as well as we should not pay for the additional costs for the shipment and penalty worth 20,000 euros that MTF has suffered ordering the goods again from another company. We are therefore asking for MTF to dismiss their damages, their claims, against SPR. So this concludes my presentation. I'd like to thank you for your attention, and for any further questions, please do not hesitate to contact me.